Ladies and gentlemen, these events are always big occasions, but today's has extra significance. This is the Blackshield Arts After Dark, in honour of the late Emeritus Professor Tony Blackshield. When we began organising this, it was to have been recognising Tony, who would have been a special guest. But sadly, he passed away just a few months ago, turning this into a poignant memorial and tribute to someone who is undoubtedly one of the most influential law scholars in the country. I certainly feel the weight of Tony's legacy in chairing such an important event, especially given the guests we have here tonight. Let me begin by welcoming them. First, the Vice-Regal couple, Her Excellency the Honourable Margaret Beazley, AC Casey, the Governor of New South Wales, and her husband, Mr. Dennis Wilson. Tony Blackshield's widow, the Honorary Associate Professor Rosemary Huisman. Rosemary's daughter, Penny Huisman. We also are honoured to have our own Vice-Chancellor and President, Professor Bruce Dowton, the Vice-Chancellor and President of the University of Western Sydney, the distinguished Professor George Williams AO, and the Dean of Macquarie Law School, Professor Lise Barry. Now, for those of you who've joined us for previous Arts After Dark events, the format will be broadly familiar. We'll have a keynote address this evening by Her Excellency the Governor, followed by a discussion with the Governor and our two panellists, and then some audience Q&A. We'll also have some roving microphones, but for those of you who are a bit shy, we'll have the Slido website. Just use the QR code. We'll get the QR code, there you go, on the screen behind me, or go to the Slido website and you can use the code number that should be, the code there that's also up on the screen. And a few quick housekeeping matters. As always, please keep your phones to silent. Should you need them, the toilets are just behind the stage. And in the unlikely event of an alarm, please take note of the exits. Or if you forget, I suggest you do what I usually do, and that's follow the Governor's security detail. First, though, because tonight we are honouring Emeritus Professor Tony Blackshield, there are also some important extras from some of our special guests. First, it gives me great pleasure to invite Vice-Chancellor Professor Dowton to the stage.
Ladies and gentlemen, colleagues, friends, I'd like to begin by thanking Peter for the warm introduction to the event this evening. These events are always wonderful events in the life cycle of Macquarie University. I'm delighted that we welcome back our State Governor and Mr Wilson to campus this evening. Please be assured always of a warm welcome at Macquarie University. It's terrific to have you both back to this evening. And I extend a very warm welcome to all of the distinguished alumni, friends of the university, the law school, the Faculty of Arts, students, colleagues and members of the community more widely. A warm welcome indeed to you all, and that warmth of welcome that I offered to our Governor is extended to each and every member of the audience this evening. It is, as Peter indicated, a special evening tonight, one of great significance in the life of Macquarie University, as we honour the life and legacy of Emeritus Professor Tony Blackshield. As Peter indicated, one of Australia's most influential constitutional legal scholars and a deeply respected member of this community, especially the Macquarie University Law School. Tony served as Professor of Law here from 1988 to 1999, and I would add even after that was a very regular contributor to the life of the law school. And during his time with us, he played a very pivotal role in shaping the intellectual culture, ambition and aspiration of the Macquarie University Law School. His landmark humour and wit, which many of us have loved to see at these annual events every year, particularly with his legendary operator-style retellings of High Court decisions, sometimes offered in a court setting itself, which I found to be quite marvellous. That reminded us that great scholarship can also be joyful, creative, and at times I found quite disarming. His warmth and generosity of spirit made him not only a very respected scholar, but a very treasured member of this community, with many of his students crediting his approach to legal education and of the persona that he had of being that which ignited their passion for the study of constitutional law, and I would add, particularly I believe, the commitment to public service, which is a very important part of his underpinning. Tony helped embed a tradition of constitutional scholarship at Macquarie, grounded in social justice, intellectual curiosity, and a deep sense of civic responsibility. I think it's very fitting tonight that we bring together this memorial event for Tony Blackshield with the Arts After Dark program. This is the flagship event for the university's Faculty of Arts. And it is fitting, as I say, that we bring these two events together and converge them in what I think you will find is a challenging and engaging dialogue on constitutional law. An exploration of the prerogative, executive, and other hidden powers and the democratic principles they test. This echoes Tony's lifelong commitment to making constitutional law accessible, relevant, and accountable to the public. An ever-relevant topic, I believe, in 2025. Tonight's program, I think, reflects the very best of what a university in a Western democracy should be about, and what for most parts of decades and centuries universities have been about in our Western democracies. Tony championed rigorous scholarship, open discussion, and a willingness to confront deeper questions at the heart of our constitutional arrangements, and I believe at the heart of the democratic traditions of the West. And this, I think, for universities at the moment and over the recent couple of years, is a very compelling refocusing of our purpose as the social license of universities in Western democracies, including in this country, has become under serious challenge. Tony Blackshield lived a life that was in stark counterpoint of any possibility that that challenge to social license should be contemplated as legitimate, in my view, in any way. We are delighted, as Peter mentioned a moment ago, to have Tony's widow here, Rosemary Houseman, and Penny, Rosemary's daughter. Several other members of Tony's family were not able to be here this evening, but we are delighted to welcome you here this evening. So I thank you all for joining us this evening. I welcome you warmly to the campus, the Wallamadigal campus of Macquarie University. And I also want to announce that tonight, and I share with you that I'm very shortly going to unveil a commemorative plaque, which is to be installed in the Michael Kirby building in Tony's honour. This, we believe, is a small, fitting and lasting tribute to a scholar whose work so deeply shaped constitutional study at Macquarie University and the consideration of constitutional law across this nation. A little later in the evening, after the events are over, I will be presenting a replica of this plaque to Tony's family so that they might have that as a gesture from the university. Again, a warm welcome to you all. I will unveil the plaque and the proceedings will begin. Thank you all for being here again. Thank you.
Thanks very much, Professor. Now, it isn't often that we let the competition onto campus, but someone else who knew Tony very well was another brilliant and eminent legal scholar, the Vice-Chancellor of the University of Western Sydney. This time we'll make an exception, Professor George Williams.
Well, thanks very much, Bruce, for having me here tonight. And I'm certainly not here on behalf of any other university, but I'm here as an alumnus of Macquarie University with my wife, Emma. Both of us enjoyed our time immensely at Macquarie University, met here, in fact, and have many fond memories and a lot of gratitude to what we received from our time here at Macquarie University. I'm speaking here tonight because I'm here to represent students of Tony's. So I'm here to speak as a student of Tony's and to talk about his influence and what he meant to me and so many others as a constitutional law scholar. I was one of those students in his constitutional law classes in 1989, Tony's second year at Macquarie Law School, and I had the good fortune to be supervised by Tony for my honours thesis in 1991. I had a wonderful time working with Tony, and I'd have to say he is unlike any teacher then or now I have ever experienced. Tony was truly eccentric, he was brilliant, and he was inspiring. When you talk about impactful teachers, you often remember your teachers for decades to come. They really imprint themselves on your memory, and Tony was one of those teachers. Decades later, I can still vividly remember Tony in the classroom, eyes closed in deep concentration, striding back and forth with a booming voice, extolling on the intricacies of the engineers case, the Melbourne Corporation case. But what was really interesting about Tony and what stood him apart was not just his enthusiasm and remarkable expertise, but to be frank, he had the best stories. Tony was able to weave in the war stories about the law in ways that transformed the dry words of the Constitution and the pages of the High Court decisions and infused them with the personalities, infused them with the people who made the law. We'd learn about Justice Hayden Stark, one of the judges in World War II, and how the deep animosities between the judges actually affected their decision-making. I remember Tony saying that for years the judges simply refused to talk to each other, and on one occasion, H.V. Evatt, another judge, went so far as to put breadcrumbs through his associate in Justice Stark's bed while they're on circuit in the hope of attracting mice and rodents into Justice Stark's bedroom. Tony's view was that the animosity had a really lasting impact to the extent that it explained many of Justice Stark's dissents, and in fact the sharpness of language between those judges during World War II. We also learnt about Chief Justice Latham's crusade as a politician against communism and how that deeply impacted his sole incredulous dissent in the Communist Party case in 1951. There were tens of these stories. They really brought the law to life. They helped understand the people and how actually the law was made. And what was remarkable about Tony was in doing so, he not only demonstrated his encyclopedic knowledge of the law, but also illuminated to budding lawyers how that law was not dry, but actually was animated by the people who made the law. And students would hang on to Tony's stories, and I'd have to say, I suspect more often remembering his stories than the law itself, because they told deeper truths about the law and the human dimensions to the making of it. What was also remarkable about Tony is that every now and then in the middle of a class, he would do something truly stunning. This often involves singing in class. I do remember a couple of times Tony simply breaking out into song in the middle of the class. I remember one of the fellow students asking afterwards whether that was examinable. They had unfortunately not got the lyrics down to the song, and I think from memory that was his 51-verse rendition of the Tasmanian Dams case, which I'd have to say at least Tony described to me had never finished every one of the 51 verses. He'd never found an audience willing to listen for that length of time. Tony gave his total commitment to his students, and this extended not just to the classroom, but absolutely to his marking. I can well remember Tony labouring over his marking. And in fact, to one extent, I remember towards the end of one semester, Tony was bleary-eyed, tired. He said he had gone without sleep for several nights, and it remains the only time I'm aware that a lecturer has fallen asleep while teaching in a classroom, whether at Macquarie or elsewhere. It's certainly the only time I've experienced it. Tony was so exhausted from marking our essays, he simply nodded off mid-sentence. We sat there bewildered, wondering how this could be, and then suddenly he got up again and kept on going, completed the sentence, and in fact was quite remarkable in his ability, interrupted by sleep, to actually complete what was quite a complex thought of his. When I got my paper back from Tony that semester, I realised what had taken Tony so long. I've still got that paper today. It says a bit as a student from 1989. I kept the paper, not only because I was so inspired by his teaching, but because then and now I've never met a marker who has written so much on a paper as Tony did. I remember thinking at the time, why was the marker not subject to the word limit? because he'd written more than I had for my 2,000-word essay. I don't know how he had fit it in the margins of the essay, but he had. Red writing, bold type, insights page after page, and he'd done that for tens, if not hundreds, of students. What also struck me about Tony was, as a teacher, his generosity to us, his students. He was never too busy, always free to talk about the Constitution, always free to inspire, to discuss. And it extended to references, supporting careers. I had the great benefit, he wrote my reference to be a High Court Associate for Michael McHugh. He wrote my reference for my first academic job, and I know many people have benefited from his generosity in that way. What I feel today is really a deep gratitude to Tony for the support he gave me in my career and so many others, for the start he gave me to understanding the true nature of the law, its human dimensions. I've tried very much to copy Tony in many ways in my own teaching. I try and tell stories. In fact, in my own teaching, including recently at Western Sydney Uni, I've told the same stories to students at Western Sydney that Tony told me here at Macquarie all those decades ago. I have not attempted to replicate his singing. I do draw the lines at some points. But he inspired me and is the reason I became our constitutional lawyer. It was as simple as that, the classes that I spent with Tony. But he's also inspired me in other ways as a teacher and as an academic. I've always felt very grateful for him, as I've said, for the support he gave me. And as a busy person, I'm often asked for some support from students for references. And to this day, I still think of Tony and think of the support he gave me. And I do give that reference, I do give that support. And that giving back is one of the most important qualities of academics and universities. And Tony really was an inspiration for me and continues in that way. I was devastated by so many people here at Tony's passing, and it's with such great sadness that we recognise the loss of one of the true giants of Australian constitutional law. It's also fair to say, though, that he left a profound impact on my life and so many other students here at Macquarie and elsewhere, and it's through us that his legacy will live on. Thank you.
Thank you very much, George. Now, the timing of this event is important, not only because we're able to honour Tony, but also because it marks the 50th anniversary of that infamous moment in our political history when the Governor-General exercised a power that most Australians didn't know at the time that he had, the power to sack the Prime Minister and the government. The dismissal has become so embedded in our collective psyche that we can refer to it now with a simple capitalised noun. It triggered a constitutional crisis and an enduring debate about just how much power the royal envoys actually have and when it's right for them to exercise it. Those powers are often invisible in everyday politics, but they can be decisive in moments of crisis with real consequences for us all. We'll be discussing some of those powers shortly, but first I'd like to introduce our keynote speaker, Her Excellency, the Honourable Margaret Beazley, AC, KC, the Governor of New South Wales. Now, before being appointed to her position in 2019, Her Excellency, sorry, forgive me, I've got a little bit to get through here. Before being appointed Governor in 2019, Her Excellency enjoyed a distinguished legal career spanning 43 years. She was appointed Queen's Counsel in 1989. In 1993, she was made a judge to the Federal Court, the first woman to sit exclusively in that court. And 3 years later, she became the first woman appointed to the New South Wales Court of Appeal and subsequently the first woman to be appointed as its president. She served several times as Administrator of the Government of New South Wales. Ladies and gentlemen, the Governor.
Thank you very much, Peter. Thank you, Vice-Chancellor, for the invitation. Thank you to the University for the invitation. May I honour traditional owners generally by many ways just saying hello to you in the language of the Gadigal people. The Gadigal land is where I live and where I work. So Butcheri Gemarua, Dian Babana Gamarada. And we all honour our traditional owners as we live, I think, on the most beautiful land, the most beautiful country in the world. I also honour not only Professor Blackshield, but his family. I know this must be a very hard time for you, and my best wishes go to you. It was about 18 months ago, I think it was, Dennis and I were invited to what is called the Aurora Ball, and it's a gay ball. And in speaking at that, I thanked the organisers for having invited Dennis and I to be the straight warm-up act to the night. In many ways, this has a resonance for me tonight because I feel that I've actually been invited to be the straight warm-up act for the rest of what I expect to be a very informed and peaked and sharp conversation, as any, I think, intellectual conversation should be. I'm also going to be a little political in this sense. The role of governor, of course, is a complete non-political position. I'm going to be political in this sense and in many ways just dodge the real question that's being posed tonight and which was introduced by Professor Greste in relation to this 50th anniversary of the sacking of Gough Whitlam, because that in many ways is a very political event. And I'm going to talk certainly about the prerogatives, but a prerogative in particular, the prerogative of mercy, and at least seek to provide for you in pretty simple, straightforward terms, in a limited time, ground where perhaps the conversation after this may take you. So let me start in this way. There is not much in our democracy that wasn't first articulated by the ancient Greeks, albeit, and I think this is very important, albeit shaped by the societal norms of the time. One enduring principle from that time has been the rule of law, and flickerings of the rule of law in England appeared as early as the Magna Carta. Picking up on its late 18th century articulation, particularly through the works of Dicey, the rule of law requires of a society that no person is above the law and there is no state punishment other than for a breach of the law proved in the ordinary way in a court of law. The rule of law acts as a restraint on arbitrary power. As Professor Martin Krieger, who was one of my colleagues at law school, and I'd also like to acknowledge another of my colleagues at law school here tonight, Professor Martin Krieger points out in his scholarly, and as is his usual way, slightly provocative article, Magna Carta and the Rule of Law Tradition, he says, arbitrary power diminishes our freedom, causes our lives to be fearful, denies our dignity, and destroys possibilities of fruitful cooperation among citizens and states. And it is the rule of law which acts as a restraint on that. And Krieger continues somewhat colourfully, not only is the rule of law never the only game in town, it never wins every game. This statement acknowledges that the rule of law can operate differently in different legal systems. As he points out, the law can be a tool of oppression as much as a key to freedom, something I'm sure our moderator tonight knows or feels still. In systems where rule of law values are strong, Professor Krieger observes that they are evident in the practices. They are evident in the practices of the law and more generally in the exercise of power. In this regard, I contend that it is not bold to proffer that this is the Australian position. Krieger's reference to the rule of law values is important. As with all values and all rights, there are invariably seemingly opposing values and opposing rights. In deliberately using the word seemingly, I have attempted to draw a linguistic distinction, not a grammatical one, the distinction between opposing and oppositional. Opposing values and rights can have a symbiotic existence, but often tussle for priority, given different circumstances as and when they arise. And thus it is with the seemingly opposing values encompassed within the rule of law and within the prerogative of mercy. The rule of law, as I have said, requires that nobody's above the law, and that punishment only be imposed for a breach of a law properly adjudicated upon by a court of law. The prerogative of mercy, however, places in the executive the power to pardon from the consequences of guilt and punishment that have already been adjudicated upon by that court of law. Whether there should remain in a modern representative democracy a place for the executive to do so has been the subject of considerable academic scrutiny, with varying answers and varying criticisms, as is the want of, and I should add, is the value of, academia. It's not my purpose tonight to engage in that polemic. That is for others. Rather, I seek to outline, as I've indicated in the brief time available, what this prerogative of mercy is, what its source is, and what its practical application is. There are various descriptions of what the prerogative is, but let me start with a quote from Lord Devlin, which I think captures its essence. Mercy, he says, is not the subject of legal rights. It begins where legal rights end. In legal terms, it may be described as the powers of the Crown accorded by the common law. In its modern Australian emanation, its source lies in Section 61 of the Federal Constitution, which vests the executive power of the Commonwealth in the Sovereign, a power which is exercisable by the Governor-General. New South Wales has no Section 1 equivalent in its constitution. The basis of the prerogative in New South Wales, indeed, as with all our reserve powers, is found in a combination of historical usage, convention, the effect of the Australia Act of 1986, its acknowledgement in the constitutional recognition of the Sovereign as part of the New South Wales Executive, and the legislative recognition of the prerogative of mercy in the suite of legislations that governs the criminal law in our state. The prerogative, as with any of the reserve powers, may be expressly abrogated by legislation. And it remains unresolved whether there may be an implied abrogation if Parliament has legislated on a topic that is covered by a reserve power. In that regard, questions of statutory interpretation will come into play should such issues arise. The exercise of the prerogative of mercy may involve the pardon of a crime or the alleviation in whole or in part of the terms of the sentence that has been imposed by a court. But what the exercise of the prerogative does not do is expunge the conviction. To the contrary, it's predicated upon the existing and continued guilt of a person. When I say guilt, that is the guilt which has been found by a court of law. It follows that it does not act as an acquittal, nor can the prerogative substitute one form of punishment for another, as opposed to ameliorating or extinguishing the punishment altogether, as it may do. In the way that it operates, if the petition for the exercise of the prerogative is received by the Governor, by me in my office, it's immediately referred to the Attorney-General for consideration, who in turn provides a recommendation back to myself or the Governor of the time, which is dealt with in Executive Council. And under our Constitution in New South Wales, the Executive Council is constituted by the Governor and 2 ministers. I point that out because of the controversies that arose during COVID, when the then Prime Minister took it upon himself to take on a number of further portfolios without fully advising many or any. We always have 2 ministers. The Attorney-General has published guidelines as to the considerations which are relevant to the grant of a petition for the exercise of the prerogative of mercy. And in brief, to explain what considerations are relative, there must be rare and exceptional circumstances to justify interference with the court's determination. And as a general rule, those circumstances must have arisen after conviction and sentence. With increasing focus on transparency, since 2018, a list is published each year of the petitions that have been lodged, the basis upon which mercy is sought, and the outcomes of those petitions. Where petitions are declined, all information is anonymised. Where a petition is granted, the name of the applicant is published. In neither case, that is, of grant or refusal, are names of victims ever identified. Between 2018 and 2023, 56 petitions for mercy have failed, while only 7 have succeeded. The purpose of the prerogative has remained unchanged over the centuries, although the practices and the reasons for its exercise have varied according to the times and the crimes. Records from the Middle Ages report its use at a time when self-defence was unavailable and execution for murder was mandatory. In the last quarter of the 18th century in England, some 200 crimes were subject of the mandatory death penalty, including for crimes such as pickpocketing. It's estimated that the prerogative had been exercised in about a third of the cases of the convicts on the First Fleet, so they had been had the mandatory death sentence imposed, and the exercise of the prerogative meant that they were sent to New South Wales. Some thought that may not have been the best result. In the colony of New South Wales, the power to exercise the prerogative was delegated by the Sovereign to the Governor by letters of commission and royal instructions. The exercise of the prerogative of mercy has been said historically to have served a vital role in the development of the colony. And records from the 19th century show that hundreds of conditional and unconditional pardons were granted each year by the Governor of the time, and in particular Governor Macquarie. In death penalty cases during the colonial times, the practice involved the trial judge actually expressing an opinion as to whether mercy should be extended. That would then be considered by the Governor as part of the Governor's determination as to whether to exercise the prerogative, but there was no compulsion on the Governor to follow the recommendation. To give examples of more recent times, the exercise of the prerogative has been of critical importance in cases of, for example, again, still mandatory sentencing, and the availability, for example, of previously unknown or unproven scientific evidence, as is demonstrated by 2 cases upon which I will touch briefly. In a Northern Territory case, a young 19-year-old Aboriginal young man, Zach Grieve, was sentenced to a mandatory life sentence for murder, which also bore a mandatory minimum non-parole period of 20 years. The murder, of which he was convicted, involved a plan with 2 co-offenders to kill a person whom they contended was abusing the mother of one of them. Mr. Grieve's case at trial was that he had decided to pull out of the murder plan and that he was, as was found to be the case, asleep at home at the time that the murder was committed. The jury did not accept his explanation that he had in fact withdrawn from the plan. He appealed. His appeal was rejected. This was the young Mr. Grieve's first offence. He was otherwise a person of good character. He was remorseful and he was unlikely to reoffend. But none of those matters were relevant in the mandatory sentencing regime, except as to the non-parole period, but which in any case, regardless of his circumstances, had to be at least 20 years. But in the course of sentencing, the trial judge commented that it was the fault of the mandatory minimum sentencing provisions which had inevitably brought about injustice. The case attracted much attention and public opprobrium. Petitions were raised and a mini-series was produced. Mr. Grieve's personally prepared application for the exercise of the prerogative was declined. To think he was just a young 19-year-old man with no legal experience and not a great deal of education. Fortunately for him, after a little while, his case was taken up by a group of lawyers And a second petition was lodged. And in their petition, very well prepared, it made reference to his moral culpability, low level of probably no moral culpability, the comparative sentencing regimes where there were no mandatory sentencing provisions and the like. And that application was successful. And he was released shortly after the pardon was granted. But by that time, he had spent 12 years in jail. As an aside, it should be noted that in New South Wales, the mandatory sentencing regime for serious crimes, that in the mandatory sentencing regime for serious crimes, the prerogative of mercy is expressly preserved. Kathleen Folbig's case provides the second example. Now, Miss Folbig was convicted of the murder of her 4 children. Appeals to the Court of Criminal Appeal and the High Court were unsuccessful. In 2018, Governor Hurley directed an inquiry under Section 77 of the Crimes Appeal and Review Act of 2001. That inquiry found that there was no reasonable doubt as to her guilt. She remained in jail. In making the finding, the inquiry rejected the scientific evidence that the 2 female children had a rare genetic mutation which was consistent with their deaths. And Mrs. Folbig's apparently incriminating contemporaneous diary entries were a central aspect of that inquiry's focus. In 2022, following a concerted campaign, including by leading medical and scientific experts, a second inquiry was conducted. This inquiry found that the scientific evidence did raise a doubt as to her guilt. But it's important to note that the medical research by that time was more conclusive, and evidence was also called explaining these apparently inculpatory diary entries. Prior to the final report being ready, the former Chief Justice Tom Bathurst, who had been appointed to conduct the inquiry, advised the Attorney-General that he had come to the firm view that on the evidence presented there was a doubt as to Mrs. Folbig's guilt, but that would take him some months to finalise the report. As I've said, she remained in jail. So the matter then came to me as Governor to exercise the prerogative of mercy. This resulted in the grant of an unconditional pardon, which in turn resulted in Mrs. Folbig's immediate release. However, her convictions still stood. As I've said, a pardon does not, the exercise of the prerogative does not expunge the conviction. So the former Chief Justice, Mr. Bathurst, referred the matter to the Court of Criminal Appeal under Section 82 of the Crimes Appeal and Review Act. And on the 14th of December 2023, the Court of Criminal Appeal found that while the verdicts at trial were reasonably open on the evidence then available, there was now reasonable doubt as to her guilt, and the convictions were quashed. She had spent 20 years in jail. There are numerous other examples where the prerogative has been exercised favourably, but it just seemed to me that these two amply exemplify its positive value in a society where the law could not or did not provide a just result. Whilst the Grieve and Folbig cases generated a great deal of publicity, and where media and public attention played a significant role in achieving a more just outcome for each individual, the prerogative here in Australia and in New South Wales, but in Australia generally, has not overall excited the political controversy as it has in the United States, where it is constitutionally enshrined and has been used for what we in Australia might consider to be overtly political purposes. Examples run through the presidential ages. Abraham Lincoln exercised clemency to encourage defections from the Confederate Army. Gerald Ford pardoned Richard Nixon, which was possibly to Ford's political ruination, notwithstanding his explanation that he had used the pardon power not only as an act of mercy, but for the wider purpose of restoring domestic faith in government after the Watergate scandal. Bill Clinton pardoned his brother following his conviction for conspiracy to distribute cocaine. It's never said whether he was a customer, but That's by the by. Joe Biden pardoned his son Hunter Biden for convictions on federal gun charges and 9 tax-related charges, including 3 felonies. Barack Obama, during his second term, launched the Clemency Initiative to address the mass incarceration and its disproportionate impact on young men of colour, addressing the federal mandatory sentencing regimes for the possession and supply of crack cocaine. The Clemency Initiative received approximately 35,000 applications. Of those, President Obama granted 1,715 commutations and 212 pardons. At that time, there were more commutations than had been granted by the 12 previous presidents combined. In his first day in office, in his second term, President Trump granted clemency to nearly 1,500 people convicted of offences in relation to the 6th of January insurrection of Capitol Hill. In the American system, one has to accept the pardon for it to be effective, and you may have read that there was one person who held out. She considered that she had been rightfully convicted and she did not take advantage of the pardon. The Supreme Court of the United States has held that the President's power of pardon conferred by the Constitution is unlimited, except in the cases of impeachment. And in the 1866 case of Ex parte Garland, the Court held that the presidential power may be exercised presumptively, even before charges have been filed. That is not the position in Australia. And while the position of the courts here in Australia as to whether the executive power to grant or refuse a pardon is totally immune from judicial review has not been finally determined, the prerogative has only been exercised on the advice of Executive Council for more than a century, initially emanating from those letters of instructions to the successive governors in colonial times and subsequently by reference to the Australia Act. However, in New South Wales, things have gone wrong. For example, following the Rex Jackson case, where the then Minister for Corrections accepted bribes in return for ordering the early release of prisoners, a further guardrail was introduced, namely the initial referral of an application for mercy to the Attorney General for advice, and I've already referred to that. That doesn't mean that the exercise of the prerogative is a tick box process, certainly on behalf of the Governor. I have had cause to engage in robust discussion with the Attorney General as to the advice, and I've also recused myself from considering the prerogative in a particular case due to a conflict of interest because I had sat on the particular petitioner's appeal when I was a judge of the Court of Criminal Appeal, and in fact had written the lead judgment. How was that dealt with? Well, the application was placed before the Lieutenant Governor in Executive Council on the next occasion when he was sitting in Executive Council and I was not available, and it was considered there. So the intention of my remarks this evening has been to give a very, very brief outline of the purpose and the operation of the prerogative of mercy, which remains one of the powers in New South Wales and across the Commonwealth reserved to the Crown. It's very brief. There are many, many more nuances. There are other reserved powers that I hold, that the Governor-General holds, the other governors across the country hold, for example, to prorogue Parliament. But I would say that the intent of the reserved powers in the sphere in which they operate is that they be used for the good of society, for the good of society, for the good of individuals, for the good of governance. They have on occasions, over the centuries, been misused, as was the case in New South Wales with the Rex Jackson scandal. However, I'm going to suggest that the occasional misuse of a power, or of a convention, a constitutional convention for that matter, does not of itself require the abolition of the power. Rather, it calls for an understanding of why the power exists, how it operates, whether it continues to have a useful purpose, and that if reform is called for, that such reform be made on an informed basis, whether it be for the abolition or for a change in processes or whatever might be necessary. And I would like to make that suggestion that when we do consider these matters, we understand what the power was that was exercised and why and how it went awry before there is an outcry without a full understanding. Thank you.
Right, ladies, thank you very much, ma'am. Before we move on to the discussion, I'd like just a very brief reminder that we're going to have the Slido website for any questions. We got that. There we go, the QR code up there. Or go to the slido.com website and use the code. And of course, we will have some roving microphones once we're done here. Now comes the cross-examination. Let me introduce the distinguished panellists, both from our own Macquarie University Law School. First, and only because it's alphabetical order, is Dr. Catherine Greentree. Unsurprisingly, Catherine teaches and researches constitutional, administrative and criminal law. She also used to be an assistant, hang on, I need my glasses. Thought I could get away with this. She also used to be she was also admitted as a solicitor of the Supreme Court and primarily practiced in family, commercial, property and criminal law. More surprisingly, she also used to be assistant editor for Empirical Musicology Review, an international journal on the history, theory and social, political and cultural facets of music. Quite the segue. Please welcome Catherine to the stage. And we have Associate Professor Shireen Morris, who's an old friend and someone who I've collaborated with on several earlier projects. She researches public law, constitutional law and constitutional reform, and worked on the concept of the First Nations constitutional voice. Her research includes work on free speech and the implied freedom of political communication, challenges of inequality and political polarisation, social media, disinformation, and helpfully, if controversially, Australian republicanism. Shireen. Governor, one of the things that you spoke of, in speaking of the prerogative of mercy, one of the things that occurred to me is that in a way that makes you or your role the kind of almost the final arbiter of judicial decisions. Does that place you above the courts in some conceptual form?
It's separate from the courts. There are some academics, and Dr. Greentree has referred to this in one of her very learned papers that I found of great assistance tonight, that some people say, well, the prerogative of mercy is the exercise of judicial power. It is simply not an exercise of judicial power. And because it's not an exercise of judicial power, it doesn't conflict, for example, with the separation of powers. It's quite a separate consideration. It takes into account circumstances which may not have been able to have been taken into account within the judicial regime. And as I said, it doesn't expunge a conviction. It simply pardons from the consequences or alleviates from the relieves the consequences of a conviction, relieves from the consequences of a conviction because you get out of jail, basically. Or it may alleviate the punishment which is involved, and so you get out of jail earlier or whatever the position may be. So your considerations are very, very different. You don't question the decision which has been made. It's there. You're taking into account other circumstances.
Catherine, I see you nodding. Do you agree with that characterisation?
I do agree, because things that can be taken into account in determining whether or not the prerogative of mercy should be exercised are things that are quite inappropriate for a court to consider. It could be changing social attitudes and values. The things that courts take into account when determining what is an appropriate sentence or whether or not a person is guilty of an offence are set by Parliament. And so there are limits on things that courts can take into account. But in exercising the prerogative of mercy, the executive is quite free to consider changing values and attitudes. They might consider the fact that a law was once discriminatory and quite unfair by modern standards.
But that in itself, doesn't that show just how fungible the whole concept is? I mean, we like to think of the law as being very clear and direct, but you're in a situation where you're trying to measure changing social values. I mean, you mentioned the case of Zach Grieve, and it's easy to imagine a time when it would have been socially impossible to exercise a prerogative of mercy in his case. How do you know when it becomes the right moment to exercise that authority?
I'm not sure I would agree that his was a case where it would have been impossible at one stage. But Alan Turing, of course, is the classic case of where a pardon was granted. That was a posthumous pardon, and times had changed remarkably.
So that comes back to that central point. How do you know at which point it's appropriate, at which point the social attitudes have changed enough?
I could throw it back and say, well, how do you know they haven't? I mean, they're in your face in large measure. But having said that, and I referred myself to the nuances, I think we are in, and this is putting it sort of very kindly, I think a hugely nuanced time of our existence. But it still doesn't mean that we don't have values. I think if, as a society, we cannot articulate values, even if, and understand that there might be a range of values, then I think we're starting to fail as a society.
Shireen?
Could I add something, Peter? What I found fascinating about your description of how the prerogative of mercy works, Governor, was that insight into the behind-the-scenes kind of push and pull dialogue that happens. And I think in answer to your question about, is the prerogative of mercy kind of sitting above the courts, I don't see it that way. To take it outside of the law for a minute, just to think about what does the Governor or the Governor-General represent in our constitutional system in a broader sense? Well, symbolically, this is the ancient spirit of the British Crown, with its Australian faces. So it's playing that symbolic role on the one hand, but the practical flip side of that is this really important power-sharing dialogue within the executive, yeah? So, and remember, in terms of how is the prerogative being exercised in a way that keeps apace with changing values, well, the changing values, I presume, are being injected from the advice of the ministers, yeah, who are elected by the people. So the advice is there, but what I think is really interesting is the fact that there is that creative tension, that dialogue, that power sharing, that check and balance happening within the executive, so that unlike America, it's not a situation where the power is being vested in the one individual, which can then, end up causing problems in the system. I think, even though I'm in favour of sort of Australianising some of those leftover British and monarchical symbols, I'm very much in favour of keeping all the power-sharing mechanisms that we have in place.
You mentioned the United States example, and Governor, you referred to a few of those, but I'm just sort of curious about what happens if you receive what might well be patently political advice on who to pardon. If we end up with a Trump-like premier, for example, who might decide that it's a good thing to pardon Rex Jackson. What do you do in those sorts of circumstances where you're getting advice from an elected premier to do something that might occur to you to be not necessarily illegal, but certainly pushing the bounds of convention?
Well, again, you go back to process. The process is a combination of the Attorney General, the Ministers of the Executive Council, and myself operating within Executive Council. I can argue until I'm black and blue in the face, but and when I talked about nuanced times before, I had in mind that, there are populist movements in Australia, for example, but there are, if that's the way the elected government wishes to proceed, and I act on the advice of Executive Council, then so be it. I can't, just like once legislation is passed by Parliament, it's not my prerogative not to give it royal assent. It's, in fact, when legislation is passed by Parliament, it's not my prerogative to even argue about it. When the regulations and proclamations and appointments come before me in Executive Council, it is my right, I won't say prerogative in that sense, but in the sense I am able to discuss those matters with the Executive Council, express my views. There have been times when within Executive Council I have expressed concern about something which, as it turned out, in the circumstances that arose, really the subject of poor drafting in the explanatory advice or a lack of clarity in the explanations I was being given, and I called for more. That is the system. But at the end of the day, we have a representative, responsible government, and that's the sphere in which the power of the governor also operates. Now, and it's where it's another sphere where constitutional conventions will operate. I haven't had matters of serious moment outside the exercise of the prerogative, but in recent times the Governor of Tasmania did. But she just acted on constitutional conventions, gave primacy to the Parliament sorting itself out. And I suppose there is one other rider that I could put on to this. I know you've started off with the talking about the exercise of the prerogative and the values that might underpin its particular exercise, but it's now, I think we would go the same way, well established in England, that the exercise of a reserve power or a prerogative power is justiciable in certain circumstances, and that was the Miller case, as the constitutional experts would be able to talk about.
Just very briefly, and Catherine, I'm just going to ask you, can you just, because the Governor has mentioned both prerogative and reserve powers, can you just very quickly give us an explanation of the difference between those two?
Yes, so prerogative powers are the historical powers of the Crown that vest in the Crown and in Australia are exercisable by our Governor-General of Australia or the governors of the states. And the prerogatives historically were the personal powers of the monarch, and they were at the discretion of the monarch. But with the changing nature of government and the emergence of very important institutions such as parliaments and executives, and therefore the divulging of powers from the monarch to those institutions, there's an expectation that those powers are now exercised on advice. And so most prerogative powers by convention are exercised on the advice of the responsible ministers. Responsible in the sense of we can identify who they are, Parliament knows who they are, and they know who to question when things are going awry. The reserve powers are different in that they can be exercised independently of advice. Now, there may still be, with the passage of time, introduction of new conventions that say even those should be exercised on advice, but the important distinction is that reserve powers can be exercised without advice, which we saw with the Whitlam dismissal.
Yeah, one of the things that you've referred to is, Governor, let me go back to some of the questions, some of the problem of defining where those boundaries lie, because You, in your own address, you described the reserve powers as a combination of historical use, convention, the Australia Act, the Constitution's acknowledgement of the sovereign as part of the New South Wales executive, and legislation. Forgive me, but that's a hell of a hodgepodge, quite a mess. How on earth are you supposed to navigate that?
For lawyers, that's not a mess.
Yeah?
For lawyers, that's not a mess. That's the name of the game.
So who do you go to for your advice?
I don't. There's no doubt about that. I don't, other than within Executive Council. If it's of any consolation to you, there has been one occasion where I took to bed with me Professor Antumi's tome on the Constitution of New South Wales because there was a little problem bubbling, and I really wanted to be very satisfied that I was well informed as to what my power was, what I could do, what I could not do, what I ought not to do, and the problem resolved itself like it tends always. I mean, we have a minority government in New South Wales, and on election night, I was sitting there watching it, wondering how this was going to play out. But again, and this in many ways was a very positive reaction, but a very positive reaction to the Whitlam dismissal. 3 independents came out and said that they would support what we in the federal sphere called supply, that they wouldn't hold up any money bills. And so, and in support of the Minns government. And that resolved any potentiality for me having to engage with the leaders of each of the parties to determine who might be able to form a government. So those issues sort of float around there in the background. As I said, the Governor of Tasmania was sitting on that for about 3 weeks. And again, as it turned out, she kept pushing them back to Parliament to sort themselves out. And they did, eventually. If they didn't, she may have had to make her determination as to who would have the confidence of the House to be able to form a government. They're the principles that sit in the background upon which you make decisions.
Shireen, you've had a good look at the dismissal, and the whole question of the dismissal has really sort of been floating around in the background of the discussion that we've just been having. Do you think the dismissal could happen today? Have we moved on? Have we evolved our political systems, the checks and balances to avoid something like that?
No, I don't think the system has changed. However, I think, look, let me take a step back a bit. You know, the reason that drama occurred is because we have, as a massive part of our system, not all of our constitutional rules are written down clearly in a way that everyone can understand. You know, a big part of our inherited constitutional system is unwritten. These traditional inherited, as you say, conventions, which is a word that basically means traditions, political norms, you know, a traditional process way of doing things, right? And one of the arguments in favour of not writing those conventions down is that they need to be a little bit fluid, a little bit evolving to change with changing circumstances, and that they need that little bit of flexibility so that they can adapt to moments of crisis, perhaps. But the flip side of that, the downside of that, is that there can be disagreement as to exactly what the conventions are. And that's what came to a head in the Whitlam dismissal, is that there were a number of conventions where there were differing views as to what was the appropriate thing to do in this set of circumstances. Was it appropriate for the Senate to block supply? Was it appropriate for the Governor-General Kerr to seek advice from a member of the High Court? And then behind the scenes that the Governor alluded to, this overriding duty to consult, advise and warn your minister or prime minister. You know, this question, that seems to be the key duty that Kerr failed in. is that shouldn't he have warned his Prime Minister that if you don't sort out the Parliament, if you don't secure supply or go to I'm going to have to dismiss you. So the way it played out, there were a number of controversial conventions, and I think the system hasn't changed, but there is sort of a political and moral sanction, I think, that has been applied in retrospect to that moment in history. And I think the present Governor-General's words, Sam Moyston, sort of, in pretty frank terms saying that she would not have behaved in the way Kerr behaved, right? So some legal scholars, like George and others, I loved listening to George and so many others debating these at the Whitlam Institute's thing down in Canberra the other day. Some argue that we need to codify these conventions so that there's not disagreement about them to stop this kind of thing happening again. Others would say, well, actually the system kind of worked as it should because there has been political and moral sanction such that the way Kerr behaved is largely frowned upon, so that it would be highly unlikely that that would happen again.
Peter, can I just,
Yes, of course.
just throw in 2 bits of information? The United Kingdom does not have a written constitution. So, an entire democracy can operate, and has. We inherited. We based much of our constitution, of course, on the American system, not entirely, but a great deal of it. Aren't we lucky we didn't get that presidential power? But just to give an example of a convention, which actually is sometimes forgotten about and did have quite an impact on what resulted in the Whitlam situation. And again, being very non-political, I make no comment about what happened there. But there is a constitutional convention that if someone retires from the Senate for whatever reason, mid-term, then that person is replaced by the same party. And that did not occur in the year or so before Whitlam's dismissal, and that had a significant effect on the numbers in the Senate.
We're going to come to audience questions in just a moment, but there is one thing that I wanted to raise, and that's, what we've discussed are the points, and particularly around the dismissal, I think, that highlights this. The points of crisis are the points at which these issues really come to the fore. And if we think of the COVID crisis, for example, and you mentioned in your speech Prime Minister Scott Morrison's decision to appoint himself as minister, again, strictly speaking, legal, but I don't know of any conventions that would have boundaried that, and certainly outside of what most people would have considered as...
The New South Wales Constitution has... Well, there are 2 aspects of that. The New South Wales Constitution provides that there must be 2 ministers at Executive Council. That was not a requirement. It's not a requirement in the Federal Constitution. But you can put in a practice that's what would happen. But in New South Wales, we had just a more secure system from that point of view.
We need to be careful, though, of not conflating, because the Governor-General's position is very different in some respects, isn't it, to yours as Governor?
It's not necessarily different. It's just that her position finds itself constitutionally stated within Section 61. But that doesn't actually tell you what she can and cannot do, or what the Governor-General can or cannot do. So in that regard, it is very... significantly based on the constitutional conventions.
The one other thing that I wanted to raise about COVID, and I think this also highlights some of the challenges that crises raise, is the point at which, the Governor-General as Commander-in-Chief called out the reserve to help in contact tracing. And my understanding of that situation was that even the Prime Minister at the time wasn't entirely sure of the constitutional footing that allowed that, because of course we don't, under the Australian law, as I understand it, it's inappropriate, or it's not right to deploy the troops onto Australian streets. Now, again, we don't necessarily need to unpack that particular situation, but my point is that it's at those times of crisis when you're forced into a situation where you really have to make some very difficult judgments, isn't it?
Look, I don't know the entire background of that other than seeing all the troops on the streets. I'd be surprised if the Governor-General made that decision without the advice.
As I understand, the advice was given, but the point was that it wasn't entirely clear, but it was generally accepted because we understood that there was a national crisis where that was appropriate. But
look, if you want to read the defence reviews of 2021, I think it is 2023, they cover this question, but they cover it on a resources basis. What happens if we're in the middle of a crisis, a plague, a COVID, something like that, and many of the troops are already deployed on the streets to that, and then there is a true military crisis. That's been the concern of the Department of Defence, as I understand it from their official documents. And for my part, I don't go beyond that.
okay.
Certainly as a matter of comment, I don't go beyond that.
Let's open up to audience questions, I think. We've got the Slido app, but we also have a couple of roving microphones. Are there any hands in the audience? Okay, well, look, let's go to some of the questions that have been sent in to us. First of all, should the public be told when there is disagreement between the Governor and other members of the Executive Council on questions of politicised pardon? Governor?
Cabinet in confidence.
That's a no. It's a very simple no.
I mean, cabinet in confidence, all these things can be abused. I mean, there is a story, no one quite knows whether it's apocryphal or not, that Joby Peterson used to load up cardboard boxes of documents, wheel them through cabinet meetings, and therefore label them all cabinet in confidence.
If anyone is familiar with the show Utopia, that was reflected in pop culture in an episode where they were wheeling documents through a cabinet meeting so that they would then be secret. But I think there's a really interesting and important thing to remember about these kinds of conversations that take place, is that there is value in frank and free discussions where those who are in those meetings are able to express their true views and can have these conversations without fear of immediate reprisal or commentary at the time, which might interfere with decision making. So it's much like we see with cabinet discussions, not having those released for a period of time. It's to encourage that free and frank discussion and advice.
Just to provide the counterpoint to that, there is a growing culture of secrecy, I think, in Australia, which, I think Australian democracy does very well by global standards in a lot of ways. But I do think that doesn't mean we don't need to be vigilant, right? And perhaps one of the areas we need increased vigilance is this pervading assumption that a lot of what government gets up to is rightly secret and kept from the public. And I completely take the point. I accept that some quick, sensitive conversations, discussions need to be made. You can't be worrying about media commentary and electoral polls all the time if you're in these massive positions of power. On the other hand, look at how the public had to wait to be fully illuminated on all the comings and goings of the Whitlam dismissal. We're only recently learning that Kerr was reaching out to Prince Charles and letters going back and forth with, Peter, I was, if that was happening today, I reckon there'd be foreign interference concerns, and they might be registering themselves in the FITS, foreign interference scheme online that Peter and I have written about. Do you know what I mean? So the public, had they known that at the time, it could have fed into some of the politics too.
But I also think that incident, we can see that the system does work for the most part, in that the palace pushed back on calls for their involvement in saying we don't get involved in the independent decisions of Australia. And so there was no advice given from the palace as to what the Governor-General should do in that situation. And so we can see that whilst our vice-regal officers, our governors-general and governors still maintain a relationship with the palace, there is that expectation that Australian decision-makers will be making decisions for Australia.
And Shireen, if I may say so, I'm going to sound very old, but I'm going to say you're very young. I mean, a lot of those things have been out in the public, forever, and they were real nothings. I mean, Kerr writes to, then Prince Charles, or Prince Charles writes to that. It really, nighttime reading, if I may say so. It seems to me, anyway. I don't think they really... I think what went on with Whitlam, the historical facts are there. I think as a country, we learned, just like with the Rex Jackson scandal, as a state, we learned, and a combination of practices and conventions have been put in place as guardrails as a result. This is the working out of a democracy, it seems to me, and I think we should be proud of that. And we talk about the codification of things, and some states have gone that way in respect of some powers. But codification also adds, and I think you've acknowledged this, it incorporates a rigidity. And sometimes I think democracy needs a little more flexibility than that.
In a way, that segues into the next question on the list, which is how can the prerogative of mercy with its political and arbitrary aspects be reconciled with the rule of law? Shireen, do you want to have a go at that?
Catherine, do you?
Or Catherine?
In a way, you could see it as being different sides of the same coin, and that if I could refer to Her Excellency's speech where you talked about the difference between being oppositional and opposing, and that they can still complement one another because we need to remember that they are serving different functions. The rule of law can be served in different ways, and these powers are vested in different people in different bodies with the expectation that they will be exercised in different ways and for different purposes. One of the things about the prerogative of mercy that I think means that we should be more open to considering its uses rather than trying to remove its availability is its ability to reflect compassion and a reflection of society to society. We kind of often think about powers as being about imposing laws, regulating our conduct. We can think about all of the different laws that we're subject to every day, and I think if you did stop to think about how many laws you're subject to every day, you'd probably go to bed a little bit depressed. But there's that aspect of these powers that can also be for good. It's meant to be about government exercising power for good, doing good for the community. And yes, we've seen examples of where the prerogative of mercy has been exercised in a way that is less than desirable, certainly for personal gain. We had the mention of Rex Jackson. There's other examples where there was a refusal to pardon a bushranger despite being given advice to grant that pardon. There have been examples where someone was given a pardon and it just so happens whoever the person who recommended that pardon owed money to this person. So we do see examples where there have been mistakes, but those examples I think are few and far between, and I would actually be far more concerned if we saw no mistakes, if we didn't see examples of where it might have been abused, because then we might think that there's a lot more secrecy involved than there is. And that point about democracy learning and being flexible, these powers will from time to time be used in a way that is less than desirable, but that in and of itself is not a good enough reason to say that power should no longer exist or that it can't be exercised in future for good.
Can I come about it also from quite a different angle? One of the things that I always remembered, and George talked about, the things that really strike you in a part of your learning, and I can always remember section from law school. Section 5 of the New South Wales Constitution. I consider that to be one of the most important constitutional provisions that you can find. It says that the government has the power to make laws for the good. I should be able to quote it now. I've sort of referred to it off enough times.
Peace, order and good government?
Thank you. Well done, Catherine. You've sort of at it more recently than me. Peace, order and good government of the state. Now, their values, peace, order, good government, their values. That's the constitutional constraint, in effect, on our legislatives, New South Wales legislative's power to make laws. Now, that doesn't mean you might think every law that's passed is a good law, but someone has taken, that parliament at that time has made a decision, having been entrusted by the people of the state as the government to do so. And there is a sense where we have to have a trust in decision-making, a trust in governance. And if we don't, we may as well hand over to more autocratic power where as a population, as a people, as the people, you're taken out of the equation.
I'm going to see if we've got anyone in the audience who wants to ask. I can see one hand here. We're going to have to, I think this is going to be the last question of the evening. If we can just get the microphone to you, sir.
This question is mainly for Dr. Morris, but I'd be interested to hear everyone else's perspective as well. It was mentioned in your introduction that you have a keen interest in republicanism, and I wanted to ask, should the Republican movement sort of pick up again, and there is a sort of an interest to move in that direction and no longer have the Crown be invested with the executive power, in your personal view, do you think that the current operation of the prerogative powers have any room for improvement that should be discussed in that Republican sort of shift? And how would any such changes, if you believe there are some that should be implemented, should be safeguarded against the sort of politicisation of the exercise of those powers that we see more so in places like America than we do under the current Australian arrangements?
Thanks for that question. So I'll just first caveat my answer with a bit of a dose of political reality. I think the political leaders of the country are still smarting from the loss of the voice referendum in 2023. Politically, realpolitik, I think it would be very unlikely that we're going to see a government trying to go for constitutional reform anytime soon. And certainly I'd be saying don't do it without bipartisan support. George's seminal book on this, 2010 or something, was right then, remains right. You need bipartisan support for a successful referendum. However, I've written on if we were to go down the path of a Republican referendum, I come from the perspective of let's look at what Republicans say they are trying to achieve and what is the best way to achieve it that, doesn't damage the constitutional system and stays true to the aspirations of that reform movement. Now, for all my analysis, I think that what Republicans are seeking is mostly symbolic. I've gone through all the advocacy and all the speeches. It seems like it boils down to a symbolic desire to remove the British symbols, the symbol of the Crown, fully Australianise it. And what scholars like Brian Galligan have said is that process has happened largely, incrementally, as in we don't have God Save the Queen anymore, we have Advance Australia Fair. Things like that have happened through legislative and policy change. But there is still some remnant ties under the Constitution that need to be fixed. So the way I look at it is that let's solve that problem in the way that changes the constitutional system the least. That would be my preference. So, you know, for example, currently the Governor-General is appointed on the advice of the Prime Minister by the monarch, right? By the British monarch, rubber stamps it. It's appointed by the Australian government, but the King signs off. That is one of the last remaining formal ties, you know, so it could be quite simple to clean that up, change that. And in terms of how do you avoid the politicisation of this role, I'm not in favour of having a directly elected president. I don't even see why you need to change the word governor or governor-general to president, you know, because the intent is not to invest this figure with presidential-like powers akin to America. In the Republican models that you see floated around, the intent is to keep the Australian system essentially the same, which I think is good. The system works pretty well. So why confuse people by changing the title Governor-General to President? That's just my view. It's probably not a very popular view, but that's the position I take.
Governor, do you want to weigh in with the last word?
It's a matter for the people.
Thank you very much. I think we are out of time. So at this point, it gives me great pleasure to invite the Dean of Macquarie University Law School, Lise Barry, to give the vote of thanks. Lise.
Good evening, everyone. As we close this wonderful evening, I'm struck by how perfectly it captured what Tony Blackshield represented. Rigorous thinking, genuine dialogue, and a deep commitment to the life of the mind. Your Excellency, Governor Beazley, your keynote reminded us why this matters. Tony would have loved all of your words. He would probably like to set some of them to music, I think. The thing that particularly resonated for me and gave me faith in our system was your words about mercy, that mercy begins where legal rights end. Professor Williams brought Tony vividly back into the room tonight, and I just love that tribute. Thank you so much. Really, really appreciate you giving your time to come tonight and represent alumni, so many of whom have spoken to me about the impact of Tony's teaching and how they have really imbued them with a love for the law. The panel discussion that followed showed Tony's influence alive and well. Peter, thank you so much for drawing out exactly that kind of robust debate that Tony would have loved in the classroom. Shireen and Catherine demonstrated, I think, the scholarship that continues to flourish here at Macquarie Law School. Vice-Chancellor, thank you for opening tonight and for the university's embrace of this event, and our thanks to Gemma Ryan and to all of the event staff for their support for this evening. To Rosemary, to Penny, to Tony's family and friends who are with us this evening, your presence here means everything. We're honoured to share these memories with you. This year marks not only 50 years of the dismissal, but 50 years of students at Macquarie Law School. And we're just thrilled that you were all able to come together tonight and help us celebrate that. Tony was there in the early days helping to build something distinctive, and tonight shows us that what he built still endures. Thank you all for being here, and safe travels home.